1,600 lawyers and accountants in the grand ballroom. On the first day I sat down next to a lawyer from Denver by the name of Henry. And as men are wont to do, we sat down in the same seats every day for 2 years and had lunch together most of the time. And we, without anything in mind, exchanged all information about each other. At the end of that period of the course, I went back to my firm for another 2 years. And then in February of 1956, I packed up my family and we moved to Denver to form a two-man law firm with the same Hayes Henry that I met in New York 2 years earlier. So that's why we're here. And as a result of that, I've had 2 children born here. I brought 2 children here. My mother and father moved out, so I felt like the Pied Piper. My brothers and sisters came out and got married here, so the whole family moved to Denver. Anyway, at that point, I was no longer, I was more like 34 years old, which is not too terribly young. But now I get back to the core of my talk. It's from the chapter in it's the second volume of my memoirs called The Gerald Waldron Matter. This was a fascinating legal matter with a little intrigue that had a 16-year life. In April of 1951, a new socialist premier named Mohammad Mosaddegh seized power in Iran by kicking out the Shah of Iran, and he immediately nationalized the Iranian oil industry, which is a very big industry. He simply froze out the Anglo-Iranian Oil Company, which is now British Petroleum, which was 51% owned by the British government. So the Anglo-Iranian and the British government immediately served notice on the world that anybody who attempted to take delivery of this oil that had been, they said, erroneously expropriated, would be not only sued, but would be boycotted, and all sorts of other things, adverse things were mentioned. Although not been involved in Iranian oil, a number of the U.S. companies, having concessions in Arabia, Kuwait, and elsewhere in the Mideast, fearful that other countries would follow Iran in nationalizing their oil interests, aggressively supported Anglo-Iranian in its efforts to have the expropriation reversed. These companies included Standard Oil of California, Standard Oil of New Jersey, Seconee Mobil, Gulf Oil, and Texaco. Now, some of these companies have changed their names in the intervening years. Understandably, all these thin oil giants aggressively attacked the legality of the nationalization and, along with Anglo-Iranian, staged a boycott of Iranian oil. Mosaddegh himself found himself with untold riches in the ground and refined products in storage, but he couldn't sell any of it. At this point enters Gerald Waldron, a 34-year-old Denver food broker. He somehow found himself with an opportunity to broker Cuban sugar, then readily available, for Iranian oil. And surprisingly, in the spring of 1952, he was able to arrange a face-to-face meeting with Mosaddegh himself in Tehran, Iran. The negotiations changed course, and he ended up with an exclusive contract for the U.S. market for 15 million metric tons of oil, with the exclusive marketing rights for the U.S. If he could simply have brokered his contract at near world prices, he would have realized a profit of some $34 million. His early attempts, begun in June of 1952 to broker his oil, were met with enthusiasm by a number of the independent oil companies and tanker fleets. In June, he made contact with City Service Oil Company, not previously actively engaged in the Mideast. W. Alton Jones was the president of the City Service, and he advised Waldron that if Waldron could get a written invitation from Mosaddegh inviting Jones to Iran, Jones would endeavor to negotiate a contract with the Iranian Oil Company to operate its oil concession and market its oil. Well, the following month, Waldron went back to Iran and got the invitation. 1 month later, Waldron went to Iran in July. He went to Iran again in August with Jones, and Jones spent a month in Iran and said he was very interested in Iranian oil. However, he made a secretive trip to Kuwait while he was there, and that kind of changed things a little bit. So when Waldron got back to the States, as late as September, he was led to believe that Jones was very much interested in Iranian oil. But in October, another city service executive advised Waldron that city service is no longer interested. Waldron also suddenly found to his dismay that the oil tankers he had engaged to transport the oil were no longer interested in doing so, and the independent oil companies that had great enthusiasm for deals they had been previously willing to make were no longer interested. Obviously, the international oil companies were hard at work. In due course, Waldron learned that city service had made a deal in Kuwait with Gulf Oil, who had the concession there, to buy a quantity of oil from Gulf. And in 1954, after Mosaddegh had been deposed and the Shah was back on the throne, the above-named oil companies were asked to help British Petroleum in operating the concession there, because British Petroleum thought that it was not politic for them to try to do it by themselves at this stage of the game, because there was a lot of international interest in the fact that Mosaddegh had been perhaps unfairly deposed. Anyway, the U.S. oil companies and the British Petroleum entered into an agreement to market Iranian oil, but they were reluctant to do this, and I'll come back to that reluctance in just a moment. Waldron learned that city service, never before a player in the Mideast, had been granted a participation in the newly formed consortium. Leaping ahead a bit chronologically, Mosaddegh, who had successfully deposed the Shah of Iran after the Shah had attempted to dismiss him, was in turn disposed by the Iranian parliament, called the Majlis, and reacting to the demands of the Iranian people, because suddenly, for a year now, they had received no oil revenue, which is what really kept the country going. Now it seemed appropriate for the international oil companies to move back into Iran. If only to frustrate a possible Russian attempt to become politically aggressive in Iran. Mosaddegh had always been suspected of having had communist leanings, and Russia had been cozying up to Iranian oil. Politically, it seemed unwise for British Petroleum to do it alone, so the British and U.S. governments, both of them, pressured the U.S. companies to enter into a consortium with British Petroleum, despite the fact that these same U.S. companies were already defendants in an enormous antitrust suit by the U.S. government for allegedly having cooperated with one another illegally. The U.S. companies were already satisfied with their other Mideast oil concessions, and that they had obtained, and were unwilling to enter into any new cooperative agreement with each other dealing with Iranian oil, unless the U.S. would grant them antitrust immunity, which eventually was done by the Eisenhower government at the outset of Eisenhower's term. This is done on the basis of national security interests. It was in this consortium that city service was granted peace. Now, back in 1952, in Waldron's efforts to realize on his contract, in his desperation to market the expropriated oil, Mosaddegh granted another exclusive contract similar to Waldron's for the European market to an Italian count by the name of Della Zanca. The count engaged a small tanker named the Rosemary, and it took on a partial load of Iranian oil at the Abadan refinery and set out for an undisclosed European port. As it entered the Gulf of Aden, it was run into the port of Aden by British gunboats, and the ship and its contents were impounded. Proceedings were brought into World Court in The Hague to resolve the competing rights. The World Court took almost 2 years to decide it had no jurisdiction in the matter. Waldron, ever resourceful, found an enthusiastic potential buyer for its oil in the U.S. Pentagon. The country was then at war with Korea and needed aviation fuel there. Waldron offered the military a favorable price for aviation fuel if the military would provide the tankers to move it. Everything seemed agreed. Waldron had been able to renegotiate his contract with Mosaddegh in order to substitute refined aviation fuel for part of his raw crude contract. Enter immediately Anthony Eden, then the British Foreign Secretary. He hurried to the State Department in Washington and obviously leaned on John Foster Dulles, the Secretary of State. Remember, Anglo-Iranian oil company was 51% owned by the British government. Suddenly, the Pentagon is no longer interested in getting oil from Waldron. It became abundantly clear that Waldron was not going to be able to market his oil. His contract obligation to take his first delivery of oil had expired on June 30th, 1953. His only remaining remedy was to bring a federal antitrust suit against the oil companies, which he did June 1st, 1956, just before the statute of limitations ran on his claim. The suit was brought against British Petroleum, Seconee Mobil, Standard Oil of California, Standard Oil of New Jersey, Texaco, Gulf Oil, and City Service. City Service had been included because of suspicion that its deal with Gulf and Kuwait and its sudden termination of interest in Iranian oil and its later inclusion in the new Iranian Oil Consortium was a result of having been bought off by the other companies. You get to a certain age, your fingerprints are off, the one can't turn faded. To get jurisdiction on all these defendants, the suit had to be brought in the Federal District Court for the Southern District of New York, which it was. The suit was brought for the sum of $109 million, which is treble damages as permitted under the antitrust law. In 1956, that sounded like all the money in the world. This was the largest private civil antitrust suit ever brought at that time. Waldron, having been acquainted with William H. Erickson, a Denver attorney who, after a short time, became a partner in Henry and Meyer, was acquainted with Waldron. Waldron came to our office in 1957 after a suit had been filed for general legal advice, and Erickson, a trial lawyer, consulted with New York trial counsel, the firm of Casey, Lane, and Mittendorf at 20 Broadway, Wall Street area. Samuel M. Lane became the lead trial counsel. Hayes, Hendry, and I, as tax lawyers, also had an important role to play. Any recovery Waldron might obtain under the suit would be ordinary income. Korean War excess profits taxes in place at that time would have taken 90% of everything he received. Our job was to try to find some way to mitigate this disastrous result. Erickson and I made a number of trips to New York, usually with Waldron, to visit with counsel. Sometimes it appeared as though we were having to represent Waldron in his dealings with his own New York counsel. Consider the contest here. Waldron was a young man of very modest means. He was facing the British government and 7 out of the world's largest corporations. He was followed by private detectives and FBI agents on many occasions, and rumors were spread that he was obviously a communist or something very much like that, for having dealt with a socialist kook like Mosaddegh, who had appropriated other people's property. Lane apparently lost control of the case early, because instead of presenting his case for Waldron, the defendant seized the initiative and took Waldron's personal deposition for 100 days, the longest deposition on record. Most of this was done by Arthur Dean, the senior partner of Sullivan and Cromwell, who later became the U.S. ambassador to the United Nations. Imagine the expense that Waldron incurred just being in New York for all this period of time. This deposition was taken over a period of 4 years. Surprisingly, one of the defendants, Gulf Oil, decided to settle to get out of the lawsuit for the sum of $1,500,000 after about a year into the case. The tax planning device we used was to have the payment spread over 10 years. This helped because the excess profits tax I mentioned earlier was repealed shortly thereafter, and after splits with his attorneys, Waldron's yearly residual payment could be received in manageable tax brackets, and he also would have a war chest to carry on his lawsuit. The deal was done in total secrecy because Gulf did not want the world, and least of all its other defendants, to know. Gulf owned a mature oil field called the Citronelle Field in Alabama. It deeded that field to a small group of opportunistic independent oil people on a basis so favorable to them that they in turn agreed to pay Waldron $1,500,000. Instead of releasing Gulf from the lawsuit, which would have been a tip-off to its settlement, we entered into a covenant not to sue Gulf, which could be done privately. Years later, I discussed this case with our then neighbor and good friend, Edward H. Walker III, who at that time, at the time of our discussion, was president of Gulf Oil, and who was an important executive at the time of the Gulf settlement with Waldron. He professed total astonishment, said he knew nothing of the settlement of the lawsuit, but always wondered why Gulf had gotten rid of the valuable oil property, the Citronelle property, at the same time it was acquiring other similar properties. We thought the Gulf settlement would be, quote, the first olive out of the bottle, unquote, and that the other defendants would come along quickly. This proved not to be true. Although we got involved in a number of possible convoluted settlement vehicles, with some of the defendants, none came to fruition. I remember spending an entire afternoon in a hotel in San Francisco awaiting a phone call from the lawyers for Standard of California regarding one of these possible deals. No phone call. Henry died in 1962, just 6 years after I joined him, and Erickson left our firm in 1969, eventually becoming a Colorado Supreme Court Justice and ultimately the Chief Justice. So I became the sole personal attorney for Waldron and his wife, and they were childless, planning both of their estates in an effort to minimize estate and income tax outcomes. Lane could never get the initiative back with respect to the lawsuit, and we were highly critical. In 1963, city service had moved for summary judgment and removal from the case, arguing that they had no business being there in the case. This motion was granted by the trial judge in the trial court and upheld by the Court of Appeals in the 2nd District of New York, and ultimately by the U.S. Supreme Court. However, these somewhat extraneous legal procedures consumed another 3+ years. The Supreme Court decision was 5-3 in favor of the defendant city service. It was interesting because of a lengthy and spirited dissenting opinion written by Justice Black and joined by the Chief Justice Earl Warren and Justice Brennan. At no time in the 16-year history of this case were the defendants required to file an answer to the complaint. And never were the defendants other than city service permitted by the court to be disposed. So you can see people in high places sometimes have influence in the courts. About 5 years after the case, Waldron suddenly died of normal conditions. His widow, Patricia, of course, carried on the case as his executrix. I had planned Waldron's estate in a way that half of his estate would go to his widow tax-free, and the other half would be retained in trust until her death, at which time half would go to named charities and the other half to her 2 sisters. There were no children or other heirs. The estate, her estate, was similarly planned. The next event of consequence involved Sam Lane, our trial attorney. He was a New Englander, trustee of Milton Academy, for example, and an avid yachtsman. My wife and I had had dinner with him at the New York Yacht Club on a return from Europe on one occasion. Feeling depressed and stressed out, he went to Boston, picked up his sailboat, and set off single-handedly for Bermuda. He never arrived. This was followed a year or so later by the death of Patricia Waldron, the executive. She was carrying on the suit. She was murdered in her bed in her Scottsdale home, presumably by entreating burglars. I must admit that we on the Waldron side entertained thoughts for a long time, and I still entertain them, that big oil companies engaged with some hoodlums to take care of this, because Waldron, by the police listed it as a burglary, only one small television set was stolen. This, of course, took a lot of the sex appeal out of the lawsuit. Only charities, in-laws, and 2 sets of attorneys, the New York trial firm and our firm, were the ongoing beneficiaries of the suit. But of course we continued. I was confronted with federal estate tax claims with respect to both estates. In typical fashion, the Internal Revenue Service took the position that each estate would be the recipient of the full $109 million that was claimed in the lawsuit. I had to file a suit in the U.S. Tax Court for both estates in order to ward off collection proceedings. Other events of interest. Shortly after Waldron's abortive efforts to deal with city service, its corporate president, W. Alton Jones, was killed in a commercial airline crash while carrying a valise full of cash from the Republican Party. The original federal judge, Judge Gerald, also died. and was succeeded by a Judge Croak, C-R-O-A-K. Perhaps with his name in mind, he determined that he would not die with this case unresolved. He summarily summoned me, then representing the First National Bank of Arizona, which was handling both of the Waldron estates, and is the real plaintiffs in the case, and our then trial counsel, William Kelly, who succeeded Sam Lane, and all of the 5 remaining defendants to New York. In effect, he said we were not leaving his chambers until the case had been settled. This we did for the relatively paltry sum of $500,000, probably a fair estimate of the value of the case at that time. Since there were no viable plaintiffs, Texaco, having a reputation in the industry for being hard-nosed, refused to participate in the settlement, so the other defendants picked up their share of the payment. Sullivan & Cromwell, probably one of the most prestigious firms in New York, who had conducted most of Waldron's lengthy dispositions, and who had been U.S. Representative of the United Nations, and other very prestigious law firms in New York represented the other plaintiffs. One of them was a gentleman by the name of Goldweight Dorr, D-O-R-R, of Hale & Dorr, a Boston firm. He was then 92 years of age. Anyway, they were all well represented, and after 16 years, the case was concluded, and I was no longer a young attorney. At some point in my 20 years of service on the board of directors of the National Club Association, a trade association for all private clubs in the country, I was joined on the board by California lawyer Turner McBain of the San Francisco firm of Pillsbury, Madison, and Sutro. We became good friends. It turns out he was a Standard Oil of California attorney whose call I awaited in the hotel room in San Francisco. At a tax conference, I met with and had a very friendly meeting with James Withrow, who was with one of the big law firms, Cahill, Gordon, Summit, I'll take time to look for it, one of the big firms. And he later came up and visited me in my office in Denver. It seemed that both Withrow and Turner had been in the OSS during World War II, and they each knew a couple of people that I knew in the OSS, in Yugoslavia. A small point, before winding up my duty in the occupation army in Japan following the war, I had signed an application for further service in the OSS in China, but nothing happened prior to my departure and separation from the military. The final oddity concerning the Waldron matter occurred a number of years later, possibly about 1989. My son Dan, sitting over there in the corner, had a good friend named Mehdi Jafari, originally from Iran. His father was visiting Mehdi in Denver, and Dan invited both of them to visit our offices that he and I were sharing in Greenwood Village. It turns out the senior Jafari had been director of marketing and exports for the National Iranian Oil Company during the Mosaddegh negotiations. He had fortunately survived the later bloody revolution over there, and he was of course astounded to learn that I was familiar with the details of the Mosaddegh and Waldron and the Mosaddegh Del Zonka negotiations, with which of course he was fully conversant. Small world. Thank you.
Out of curiosity, Bob, what was the value of the estate when you took over as for attorney?
We finally settled on the basis of what they actually received, which was less than $109 million. So that worked out okay.
And who ended up getting the money to charities or whatever it was?
I think Little Sisters of the Poor were one of them, I forget the other one, and then 2 sisters of Patricia Waldron, the widow, for a time. But it was kind of fascinating for a period of time.
What was Patricia's background?
I beg pardon?
What was Patricia Waldron's background?
Just a housewife. Just a housewife.
Ladies, you resent that?
Well, she was a very attentive housewife. She had no children. Any other comments?
No other comments or questions from Bob?
When you were involved in this, Bob, you undoubtedly had other things going on, didn't you?
Oh yes, yes indeed. 16 years of it. Yeah, a lot of other things.
kind of other things, Bob, just out of curiosity?
Joe, you had a question?
The movie Argo just came out, which depicts...
I'm sorry?
The movie Argo just
Yeah,
came
Argo.
out recently, and it depicts events around the Iranian Revolution, the one before last,
Yeah.
the successful one. And in its introduction, there's a voiceover for a couple of minutes, and it basically depicts Mosaddegh as a real hero of the Iranian
Oh, yes.
people, and
And
the
he
Shah
really
is
was.
and the Shah is this horrible oligarch who
Yeah.
murdered and tortured everybody in the country. Is that consistent with your experience of...
No, because I certainly had no personal contact with the Shah, but this is a little add-on. When the Shah was still in power and Jimmy Carter was the president, he had had a great New Year's Eve party at the Shah's place and thought it was wonderful when he gave this lavish speech about how the Shah was a beacon of honor and security in the Middle East. The following year, after the Shah had become ill and was looking for a place to die, actually, wanted to come to the United States for medical treatment, Carter was under the country.
Well, that's interesting, because in Argo, they keep depicting the Iranians as trying to get the United States to render the Shah back to Iran for justice, as if
Oh, I
the
think
Shah
that's
were
right.
in
He
the
ended up
United
dying in
States.
Egypt.
Okay, so I wonder why they're depicting the U.S. as having had him in there.
Well, he eventually Carter relinquished, and he came
Ah.
back for just a short time in one of the hospitals, and then they eased him out to Egypt.
Before that, he had to hang out in Cuernavaca.
Beg pardon?
Before that, he had to stay in Cuernavaca,
Yeah.
Mexico.
Yeah, he went to Panama and a couple other places trying to find a place to be taken in.
Wasn't Mosaddegh helped in his takeover from the Shah by the Russians?
This is my grandchild, 14 months old. I have a granddaughter, 28 years old.
Slow learner.
Nice looking granddaughter.